esteemed colleagues, and my cherished friends, I, Rima Bhandari, am deeply honored to host this momentous occasion that is the first day of our fifth virtual International Mediation Summer School. I again extend a warm welcome to all the participants, distinguished speakers, and organizers from around the globe. We are privileged to have this event hosted by the esteemed Nivaran, mediators of the Supreme Court of India, in collaboration with Commonwealth Lawyers Associations and the Singapore International Mediation Center. Now, this collaboration highlights the critical importance of mediation in our interconnected world. It is truly inspiring to witness such a diverse and accomplished gathering of legal professionals and mediators united by a shared passion that is resolution of disputes through mediation. The enduring popularity of our this annual summer school underscores the growing recognition and significance of mediation. From July 26th till August 6, 2024, we embark on an enriching journey through a meticulously crafted program that is 10 sessions on mediation. Each session aims to deepen our understanding, refine our skills, and expand the practical application of mediation in our professional lives. Nivaran has been a beacon of enlightenment in mediation, pioneering numerous transformating initiatives. To date, we can say that we have curated an impressive portfolio of 35 online guest lectures, seminars, interactive chats, alongside several physical events organized by Nivaran. In response to the global challenges, Nivaran has transformed obstacles into opportunities, that is, by inviting distinguished experts from around the world to educate and inform us about the consensual dispute resolution through mediation. Through webinars, discussions, and lecture series, we have hosted esteemed figures, including honorable judges of Supreme Court of India and High Court, who have generously shared their invaluable sides from time to time. Well, it is not enough. As we have moved forward, our dedication remains firm to enrich the field of mediation and leave a lasting impact on the global mediation community. With your continued support means our collaborators, our participants. With all of your support, we will advance lighting the way forward towards a peaceful and effective conflict resolution. Mediation, I just want to say, since I'm also a mediator, I can stop myself from saying so. It's definitely a powerful and a transformative tool in the quest for justice and conflict resolution. It offers a harmonious, cost effective, and expedient alternative to litigation. Throughout our sessions, we will explore a rich tapestry of topics from foundational principles to advanced techniques and real world applications. We will immerse ourselves in case studies, participate in interactive workshops, and gain insights from some of the foremost experts in this field. Our ambition, it extends beyond learning. We aim to engage deeply, share experience, and cultivate a robust network of professionals who are dedicated to advancing mediation. Whether you are a seasoned mediator or a newcomer or a student, anyone, I can say that this program promises to provide valuable insights and practical knowledge for your professional journey. I urge all the participants to seize the opportunity presented, engage passionately in all the discussions, pose thoughtful questions, and forge connections with your peers and our esteemed speakers. This platform, I would say, is a rare and a precious opportunity to enhance our collective expertise and promote mediation in diverse legal contexts. Before we proceed, it is my distinct pleasure to introduce our guest speaker for today, that is the esteemed Miss Rene Mercedes Baptiste. Miss Baptiste is a luminary in the field, and we are profoundly honored to have her share her insights with us today. Ms. Baptiste's illustrious legal career spans several decades, marked by significant accomplishments and contributions. She has held numerous esteemed positions. I will take a lot of time if I talk about all of them, so I'm just mentioning few. That is, which includes founding her own law practice, serving as a Commonwealth election observer, and leading various legal and community organizations. Her dedication to legal excellence and education has left an indelible mark on the legal landscape of St. Vincent and, Gar- and Grenadines and beyond. Today, Ms. Baptiste will be speaking on introduction to mediation, its definition, its process, how it is different from different kind of ADRs, its lacunas and disadvantages. Following her presentation, after that, we will open the floor to question answer session. Please share your question in the chat box and we will endeavor to address as many as possible if the time permits. Without further ado, please join me in extending a warm and enthusiastic welcome to our distinguished guest, Ms. Rene Mercedes Baptiste. All over to you, ma'am. And thank you so much again for being there. A huge round of applause. I think we can do it like this online too. Welcome, ma'am.
Oh, thank you so much. Thank you so much. And I want to thank Navarre for this invitation to be here today in the capacity as a lecturer in this particular series. I've had the good fortune to be introduced to this series by Senior Santan, and I find it most refreshing and educational. I know that sometimes folks don't like to go to continuing professional education sessions, but it is most important to remain current and also to widen the scope of your legal knowledge. And this is an excellent opportunity. I bring you today greetings from the Eastern Caribbean, from St. Vincent and the Grenadines, which is one of the circuit courts of the Eastern Caribbean Supreme Court. In their summer school, I've noticed a number of distinguished speakers, and I feel like the newest kid on the block getting my first candy to make a presentation. Judges, panelists, mediators, legal practitioners, and esteemed seniors, good morning. Basically, I decided after being in practice for over 40 years to learn more about mediation. And I became a certified mediator in 2018. That's because having had previous experience and you didn't know at the time that this was mediation, but you know from other aspects of your career, you did arbitration at some time, you were involved in arbitration at some time, in conciliation at some time, because in my background as a minister of labor, I was involved in conciliation, having talks with the labor unions, trying to get them not to pound the table, but let's sit down, put proposals, speak with each other. And in my church organizations, in all church organizations, you're going to have all flavors. And that's where, again, you realize that this skill was being built up over the years so that you can bring people together, lessen hostilities, lower the temperature, and everyone goes away fairly happy, if not 100% satisfied. Now, the introduction to mediation, and I speak primarily from my experience in St. Vincent and the Grenadines and in the Caribbean region. We were awestruck by, when you enter the legal profession, by the elocution of our seniors, the language that they used, the way they presented themselves in court. And you dreamt of being able to move a jury to tears. We were bred on and nurtured in the tradition of adversarial, court-adjudicated disputes. That's what we were nurtured on in the 20th century. Then it was at the turn of the 21st century, our Eastern Caribbean Supreme Court, our Chief Justice, thought that in the administration of justice, let us redraft, as we were preparing new Supreme Court rules, let us redraft and introduce mediation formally in the court administration system, in the court system, into the justice system. And the first set of rules were drafted 2003. And that it was a bold transformative step to introduce this process of mediation. It was sold as being cost-effective. That was the number one reason to go towards mediation, because litigation is not cheap anywhere in the world, and that includes in the Caribbean. It would be timely. It would, quote unquote, heal relationships, because very often when people left court, there is a winner, champion, and there's a loser in tears. There would be no formal rules of procedure. People would be able to speak. They will feel they have their hands-on and not just their lawyers. And sometimes their lawyers will be saying things they don't understand. So this procedure for mediation has helped to bring people closer to the justice system and begin to understand more of the justice system, rather than being told about witness statements, the rules of evidence, that is hearsay. No, you can't speak. Now the litigants have a procedure and a voice in the process of their own litigation, in the process of the court proceedings. Mediators had to be trained. Mediation coordinators had to be put in place, as well as for the referral coordinator had to be also put in place. This meant selling it, of course, across the various registries and having people trained and ready. What else was expected? A mediation memorandum. So lawyers had to now sit down and draft, there were guidance rules provided, a mediation memorandum. What was this memorandum going to do? Because you had already drafted your claim or your other the pleadings, and now you had to summarize them in fairly simple language, summarize the issues, the matters that are in dispute, and give an indication of the position being adopted by this party, and the other one would give the position being adopted by the other party and submit that memorandum. Then you have to create now the mediation session. What would this session be about? A mediation session was told to last 3 hours, giving enough time for the parties to settle, sit across the table, and try to melt the atmosphere a bit. And it is going to be continuous for the 3 hours. There will be, as is explained by the mediators, there will be an opportunity for caucus. You can caucus with the mediator and you can caucus with your lawyer. And both parties will have that opportunity. The parties have to attend, and there, of course, will be a fee. The fee in our process was that each party will pay $450 EC, which is just under 200 US dollars. Each party will pay that. And out of those monies, the mediator is paid and the court gets something for the administration. The mediation office, it had to be explained that the mediation office is also part of the court office. It's not just something the judges or the lawyers put together there to try to sell out the case, which is the sort of terminology that would be used in our vernacular in the Caribbean. But this is still part of the court proceedings. The parties, of course, wanted to know, what could I say? Would I be able to talk? Yes, parties are able to talk. The mediator is the person who, you wouldn't call him a referee, but he would explain his role. He or she would explain their role. What are they here for? To allow the parties to have the freedom to explain the issues as they understand it. Each party, they are free to have their lawyers with them, or they may ask for their lawyers not to be there. They just want to sit and talk out the issues. So they will explain what they believe their claim is. Because I'm quite sure as practitioners, you would know that lawyers, we write in a particular language. That's the language of our profession. But the language of our clients is not necessarily the language that we use in our claims. So they will explain what they know, even though you brief your client, because I have been in mediations, you brief your client and explain to them what's going to happen. You still hear them say, well, let me tell you what is my side. So the mediator allows them to say what is their side. The other party will say what is their side. And you ask them, what you have in common? And they will start saying what they have in common. And I've seen litigants, the temperature just goes right down and the sea becomes calm and glassy sea. Because they're now seeing each other as individuals. They're now seeing each other's, but I know you and you know me. What are we doing here? Why are lawyers here? And they discuss their case. The mediator says, is that what you agreed to? Is this what you would like me to write? And help them along in that particular journey. On the court side, of course, you must have the memorandum and the referral order from the court saying, we've referred this matter to mediation. That does not preclude that before even the matter is filed, or the matter is filed and has not reached case management, that you cannot ask for this to go to mediation. Because sometimes in having your private discussions with your client, you see the matter is something that can be resolved by mediation, rather than the adversarial nature of, let's go pull two swords and have a sword fight. So this procedure, you tell them 30 minutes, you can have a break, you can talk to me as your lawyer, I can be present inside or outside, there would be time for you to caucus with the mediator. And with my experience, the caucusing with the mediator of each party has been, it's a wonderful thing to see after they come out from the caucus. You see all these smiles. All of a sudden, people who couldn't stand each other, they can smile. The cases for referral is often, it's done by the judge or the master, or sometimes the attorneys, when the first case management, or before, as I indicated, would indicate, I think this can go to mediation. And so you prepare the documentation, the memorandum for mediation. The parties must be willing. And most times they are, because they realize it's going to cost them, the litigation is costly. They know that from the outset. So they are willing to let's go and talk. And you explain that this is a collaborative process. We're going to try and sit down and work out what it is that we have brought to the court or going to bring to the court. These opportunities for gains should not be missed. It must be, of course, some issues that are really ripe and proper for mediation. What happens with the referral? I have heard a litigant say, wow, so I'm in charge of my litigation then. I don't need a lawyer. Would you excuse me? And here you are being very serious in relation to this. And your parties have decided now that they are in control. So it gives them that idea that justice is not so far removed from them, but they are part and parcel of the whole procedure. They don't just come sit in the back or sit over there, the lawyer says sit and don't say anything. They are now part of it. The personality of a mediator has also some bearing. because I have been in mediations that have been successful, those that have failed, because sometimes the personality of the mediator may get in the way. So the mediator has to understand that they do not allow themselves to be drawn in on one side or the other, but to work towards a collaborative approach and not give the idea either that they are substitute for the judge. A mediator cannot be called as a witness, cannot give evidence after the mediation is completed, nor can he say what has taken place during the mediation, because it is a confidential procedure, confidential sessions. Mediations may complete in the 3 hours, may ask to come back to another session and complete it. And of course, the parties would have signed that they are agreeing that this is confidential. At the end of the mediation session, the notes taken by any party are to be destroyed right there. Destroyed. So nobody has anything to go and say what happened in the mediation session. Then the mediation report is prepared by the mediator and signed off. It's not finished there. Each party has to do what is called an evaluation report. So the litigants on either side will complete an evaluation report, and the legal practitioner who was there when it was referred, who was inside during the time with the parties, the legal practitioner also has to prepare an evaluation report, which is filed with the mediation report from the mediator, the evaluation report from the litigants, and the evaluation report from the legal practitioners, so that the judge, when the matter comes back to case management, the judge will have an opportunity to assess what took place in the mediation. A successful mediation could lead to partial agreement on some of the issues and some issues not completed. So you may have an agreement on part of the issues and some issues still to go through case management or go to trial, may reach the trial. Or you have a successful mediation, complete agreement, parties signed off, and then the judge will ask for this settlement agreement to be reduced to an order. And the lawyers and the parties are present when the judge, in reading the settlement agreement, will then reduce it to an order. And sometimes the lawyers themselves would produce a draft order for the benefit of the court. The court may amend it accordingly or may agree with it and give its approval, and the matter ends there. There's, of course, a timetable with the number of days given for you to settle, the number of hours, the 45 days for adjournments, the availability of other mediators. Sometimes it may even go to an alternate mediator if things do not work out as anticipated. As we go now to the end here, we look at not only repeating, and we always have to stress this, what is the benefit of this mediation? Is it cutting justice short, or is it beneficial, really beneficial? In my experience, the business people are not so attuned to mediation, but the ordinary citizen is in favor of mediation, but you have to constantly build public awareness about the benefits of mediation. Not just the costs, the reduction in the time, because litigation you often heard it said, litigation is costly. And the time reducing for the court proceedings could be long and drawn out. It could be a year, 2 years, even 3 years. And then it may lead to the failure to resolve the underlying issues and result in even more disputes and another different type of dispute arising. But preserving relationships, giving people an opportunity to feel that they're part of the system, and that the system is not rigged against them, as they say, or the system is not in their favor. But the longer that they are exposed and listening to the mediator, the more comfortable I have seen in my experience. Very, how should I say, people who are absolutely suspicious of lawyers and all these people, you see them getting to understand, especially if there's a second session, they get to understand and feel that they not only preserving relationships, but the confidentiality, other than sitting in a civil court where there may be the media present, there may be other persons present and listening to them giving evidence, but the confidentiality gives them an increased comfort in airing their issues, how they understand them. And then, since it is in the court, but it is voluntary, but they have also consented, so that it brings the parties, the participation of the parties is much more than if you were strictly telling them, well, come back, we're taking the witness statement, we're going to go to the registry and file it, we have disclosure to make. They don't know what is standard disclosure. They don't know what that is. You know what is standard disclosure. But they're sitting there and listening to the proceedings of mediation gives them that great comfort. Finally, the introduction of mediation has eased case management significantly. That's what I have been advised by the High Court administrator, because it lessens the pressure on the court and the court staff in not only preparation of their list, but also in preparation of the files and the disposal of cases. Now, in our system, to conclude, there's a National Mediation Committee, which is comprised of a resident judge as the chair, the registrar of the High Court, a representative from the Attorney General's office, a representative from trade unions, a representative from the Chamber of Commerce, a representative from the Employers Federation, a representative from the religious organizations, and a representative from the bar. The court administrator is the secretary, and they are encouraged to meet either every month, but once a month, give a report on a quarterly basis to the High Court, the judge who is in charge of the committee, and they also must give one to the Supreme Court 3 times per year, and they also have to account for the funding that has been made available to assist the court to keep the mediation office, pay for the electricity, the cleaner, and they usually have a little drink apart from water. They have a little Milo, a little chocolate drink or something to help people relax. So that's where that funding goes to. In relation to our system, there are about 25, 30 persons who are trained for court-connected mediation. The situation has arisen where some persons may have done mediation in other jurisdictions, and so they have to apply to the court, showing them their certification and why they should be considered to be put on the roster to work along as court-connected mediators. So that's the terminology we're using, not just a mediator. Now, I'm a court-connected mediator. I am a mediator, sorry, but I'm not a court-connected mediator. And I took that very conscious decision because having been involved in different organizations, invariably I might be meeting persons whom I probably would have some interest, and I ought not to have an interest. Being a former politician, somebody involved in different NGOs, I took the conscious decision, and other lawyers, that we would not apply to be court-connected mediators. But we are mediators, and we will do it in our private setting elsewhere, but not in court, not as a mediator on the roster to be available for appointment by the judge. Thank you very much.
Okay, so thank you, Rene, I would say, for a wonderful session. Well, I just want to say that it's really nice to hear how mediation evolved in Caribbean with the help of your court. And I would say that similarly in our country also, our judiciary has played a very important role. By there are a few important judgments. One is Afcon's case and one is Salim Bar case, according to which there are rules framed for mediation by various high courts, and we are right now we are working with those rules. The Mediation Act has been there, but it has just to be come into force. We are all are waiting for that.
Oh,
There are
I should
yeah.
state, we do not have a mediation act.
Oh, so we are better off then.
Yes, I know. I saw India's was last year. It
Yeah,
went to Parliament. We do
yeah,
not have a mediation act. I think Trinidad and Tobago
yeah.
has a mediation act. But in the Eastern Caribbean, which is St. Vincent, St.
Mhm.
Lucia, Grenada, Antigua and Barbuda, St. Kitts Nevis, BVI, Montserrat, Anguilla,
My
we do
goodness.
not have individual.
It is here also. It is after a lot of efforts. Now we are there with the act. So more or less, what I could understand, things are same in India with regard to confidentiality, according to the court annexed mediation and the parties' determination, and how and I also want to say one more thing, that like in your country in India also there can be partial settlement, there can be complete whole settlement. Some issues can be left for the court decision, some issues can be decided. The only difference I see is that we are, again, I would say, better off is that our court annexed mediation mediate, the parties are not paying anything. It is actually through our judiciary legal service authorities. The payment is made to the mediator. It is totally free of cost for all the parties. I think this is done to make people more aware about mediation so that they can understand the benefit of mediation. As of now, yeah, you
Yeah.
want to say
Our
something?
case, there is a means test. So it's not everybody who can pay that money.
Yeah.
It's a means test, and the
Okay.
high court admin would interview the
Great.
parties to really find out, yes, I don't have the $450. And that would then be informed to the mediator in
So
relation
I
to that.
think, yeah, so we should also try to bring these changes. Right now it's free of cost, and we all mediators, I'm also a quota next mediation, so we all are doing uh, initially actually we lot of us we did pro bono also for many years. There are a lot of friends of mine I know, we did pro bono, we didn't charge anything. Now also we are paid, but a very nominal good amount paid, but not by the parties at all. And secondly, I totally agree with you when you said that justice is not far away when parties they start talking with each other. I really like the tagline. I will use it when I will speak about mediation somewhere, because when people start talking with each other, when they feel that there is no need for a mediator also or a lawyer also, then definitely the justice is not far away from them. And lastly, one more thing, as you rightly said, that we need to create more awareness about mediation. That I think that is why Nivaran is coming up with a lot of summers, this summer schools and lot of lecture series, and that we are doing this so that we can create more and more awareness about the benefits of mediation, and so that people can, look for mediation before they go for litigation.
Mhm.
So before,
But what we discovered as well, in our public awareness outreach, we try to get on the main street. Remember, this is a very small country. Huh? We have 100,000 people.
yeah,
So we go on the main street near to the telephone company office. Everybody got to pay telephone bills. So we go
oh,
in that street and people would be passing. They would see one of our committee members. He's the president of the teachers union. So
mhm,
people would see him handing out the leaflets and they say, what is this about? And we sit and we discuss and tell people, what this
yeah,
mediation is about. And it sometimes ends up being right there. Somebody may ask for a private session. So we have the front side and go for a private session, go behind, and then
yeah.
they come up, well, I didn't even know that this could happen.
Yeah,
You know,
yeah, that's true. No, that's a
it's,
good
yeah.
idea. Even we can start. I think that's what good idea coming from you, and that is what we want to learn from each other. Like these kind of programs, we are able to learn so many things from each other, and I think we should also do such kind of things in future, to create more awareness in our country also. Rene, there are a few questions. I just
Yes, please.
they are there in the chat box. So one question is, Who can become a mediator? Is that person is necessary to be a lawyer or a person who has a knowledge about the legal field, or anybody else can also become a mediator? So this is the question.
Right. Anybody can become a mediator.
Yeah,
An adult.
yeah,
We haven't had
yeah,
teenagers or
yeah.
nobody in their 20s, but an
Thanks for that.
adult with some good experience. And what we have discovered from the persons who have expressed an interest,
That's
most of them are teachers or retired teachers, public servants or retired public servants. We've had the headmistress of an all-girls school, town planner, land surveyor. We've had, I think, 2 pastors,
yeah.
religious persons who work in the Social Security office,
Securities.
because, they meet a lot of people.
People.
So meeting so many people, yes, you may have good communication skills, but this skill is a little different from good communication skills, in that you building on this consensus, how you bring people together, not just how you could sell it, but
Yeah.
how you bring people together.
So in India
We've
also
had
we have this.
accountants. We've
Yeah,
had accountants, yeah.
yeah. If you have taken a training, anybody can become a mediator in India also. So, and the second question, Rene, is how effective is institutionalization of mediation, particularly because it is a process of self-determination and voluntary participation?
Okay.
Yeah.
It's been institutionalized because I think the court felt that if it is part of the administration of justice, that people would cling to it. Now, as I've indicated in my introductory remarks, that being a politician, you have to quell jealousy issues between your supporters
Yeah.
and issues with the opposition. And you definitely hone some skills there, because you have to bring, husband is for one party, wife for another party. So you learn how to mediate different issues.
Yeah.
And we know our society, we know our culture in the Caribbean. So this institutionalization, we know, yes, give it a chance, it will work. And it has worked. In some countries, more and greater levels of success. In some, you have maybe 60, in some 70, 80, 90%. And it all has to do with the amount of selling that you've done. In some jurisdictions, we know we go to the schools, the senior classes in the schools,
Yeah.
because they know that's where people begin to have their issues. And the children, when they come to the session, we do a mock mediation for them. The bar members will do the mock mediation. And then you have the children asking the questions. And when you listen to what they're asking you, you realize what is happening in that particular level of the society. Because there are things they would never tell their parents.
Yeah, I
Never.
totally agree with you. Institutionalization is very important in our new act of mediation in India also. I'm just adding a side by side what I know from our countryside also. Now it's going to be institutionalized, and there should be, there will be rules according to that. It will be done, and there will be mediation service providers who will be, certified, and they will be enrolled with the Mediation Council of India. So in India also, it's going to be totally, we would say, after the act there will be a transformation, and it will be institutionalized here also, Rene. So meanwhile, I'm just getting to the another part of this question is, are there any efforts taken to develop a collective pre-mediation psyche of people at large?
Yes, I was just indicating.
Yeah, you are right now.
Yes, we even go
Yeah.
to the churches, Saturday or Sundays, and do a session coming towards the end of the service. We explain what is mediation, what it is about, and we get very deep questions from members in the religious organizations asking us. And of course, sometimes they would ask questions in relation to matters of a criminal nature. Now, I must say that the mediation that is in our rules is geared towards civil proceedings. However, and it's even said that this would not apply to family, probate, etc. But in relation to family proceedings,
Yeah.
we found it, the parties want to go and sit and talk.
Yeah. See,
Okay?
there are emotions involved, I would say. In family matters, there are a lot of emotions. So mediation, I would say, is the best answer.
Then we have another session we call community mediation.
There's
Because
a
things do not
question.
happen in a vacuum.
There's a question on this also. I will read, then you come to community. Just read that there's a question on community mediation. How effective is community mediation? And the state of, okay, it's saying state of Maharashtra and India has one such initiative, which is Tanta Mukha Tanta Mukda Gaon, that is conflict-free village. So the
Okay.
question is basically in India, the initiative has just been started in one of our states, that is Maharashtra. But the question main is that how effective it is, maybe in your country, the community mediation.
It recently started, was under 5 years. And there are 2 lawyers who are mediators, both that do court-connected mediation, and they volunteered to take the course in community mediation. And the course was also offered to teachers at the college level. And the report is they have done a few community mediations, not that many upon which you can pass a judgment as to how well it's doing. And because of that, at the mediation committee level, we want to continue going into different areas. You know, we go down to an area where it takes you 2 hours to drive and go. We go there and we try to get the community to come out. We had one in one of our Grenadine Islands, which is very small. It's got about 4,000 people on it. And we did it under the famous, it's called the famous almond tree. That's where people go and discuss politics, religion, you name it. It's done there. And so people come there, gather, and you talk to them about it, and they talk with you. And the report is that people were so appreciative that you had people, lawyers, sitting and discussing something that can affect their everyday living. And this gives a degree of comfort and confidence that the system is not always against me, that you don't want to have anything to do with me, but that the system is reaching out to you to help you with what your problems may be before you get into trouble, when you might likely to get into trouble, what are the consequences. So there's that outreach that continues. But to give you a concrete success rate of the community mediation, that has not yet been reported on. Alternatively, I can tell you that with a very large corporate organization, and I recommended to the management an issue that was heading straight to the cliff. I said, listen, go to mediation. I'll give you the name of 3 mediators. And when I went back to them, the CEO saying, man, anytime I have a problem, mediation. I'm so sold on it that I do not have to have this. It's not a battle. Instead, let's have a discussion. Let's talk. What impressed him most of all during the course of the mediation session was the caucusing.
Yeah.
You break, and the mediator caucus with one side, caucus with the other side, give everybody a little space, a little breathing room, and come back. And that was, he said, the most important part to him of the mediation session was the caucusing.
Yeah, the separate sessions are very important because only then you will be able to get, the most important confidential information or the underlying interest of the parties that can only be, one mediator can understand if that's caucus or separate sessions are taken by him or her. Well, there's another question, Rene, by Swapna Sundar. She's asking, can we have mediators from another country mediating a dispute in India? So yes, we can. I think Rene, it's because can we have it in India? Would you would you like to answer this?
Well, let me put it this way. The East, I just described to you the Eastern Caribbean, right?
Yeah.
All the islands.
Yeah.
Okay. And our experience is one of our mediators, he is requested to work in another Caribbean island. Sometimes his calendar, he has more cases from outside of St. Vincent in other Caribbean islands because he built a good reputation in St. Vincent. And so in that, he's just excellent. Getting people together, speaking, getting these issues ironed out. And so lawyers and friends tell each other. So he goes to the other jurisdictions as well within the Eastern Caribbean because his qualification is for that. And as I've indicated, there are persons who are trained in other countries, and the Chief Justice, through her Regional Mediation Committee, they would look at that and see whether or not that person qualification matches what we have done in our setting. And they can take the decision. It's in the rules. They can take the decision. But it is, at this time, limited to CARICOM countries. And just before I came in, I was looking at the section where, yes, in our practice direction, it says, and I read it as follows. The Chief Justice may from time to time advise on the process and procedure for persons who have been trained in mediation from other jurisdictions within and outside of the CARICOM region. So this is the Eastern Caribbean Supreme Court is the OECS, the Eastern Caribbean. So its scope is widened to CARICOM, and CARICOM would include Belize, Suriname, Trinidad and Tobago, Guyana, Barbados, Jamaica. And of course, we have Haiti and Dominican Republic, but because of language issues, you're not likely to get mediators from there. Within and outside of the CARICOM region, to be allowed to be placed on the roster of mediators for a member state or territory within the jurisdiction of the Eastern Caribbean Supreme Court. I'll read that again. The Chief Justice may from time to time advise of the process and procedure for persons who have been trained in mediation from other jurisdictions within or outside of the CARICOM region to be allowed to be placed on the roster of mediators for a member state or territory within the jurisdiction of the Eastern Caribbean. So that's your answer.
So so it is possible.
Rima, can I just come in for a minute?
Yes, please,
yes,
sir.
Rene, also in the Mediation Act of 2023 in India, now according to Section 8, unless and otherwise agreed upon by the parties, a person of any nationality may be appointed as a mediator. And I'll just read the proviso. Provided that the mediator of any foreign nationality shall possess such qualification, experience, and accreditation as may be specified. So I think it is now in our statutory law itself, now it has been stated that a person of any nationality can be appointed a mediator. Only he has to fulfill these qualifications which are laid in the Act. Thank you very much.
Thank you, Rajiv, sir. So clarifying the position from Indian perspective. Thank you so much. Rene, the another question is, how does your country handle quality of mediator, and are there any rules regarding quality of training? So basically on the training process.
The training process, the syllabus is determined by the Judicial Education Institute. In the Eastern Caribbean, there's a body established under the Eastern Caribbean Supreme Court administration called the Judicial Education Institute. And they provide training for continued professional development and continuing legal education, together with the University of the West Indies. And it is linked to the University of the West Indies for the purpose of accreditation. The lecturers come from the Faculty of Social Sciences. So at the end of your training, we recently requested for a refresher course for persons who are trained in the first batch of mediators and the second batch of mediators. And as you know, the training for mediation has to be hands-on. It's wonderful doing some things online, but mediation is a practice that is going to be close up.
Yeah.
So they will come to like one island. We have requested them to come to do a refresher course, and we have to tell them we have 25 persons who are ready for training and or refresher training. So it's done because the court has to make sure that your skills are still sharp and that you are still using the tools that have been provided and not substituting some other tool other than the tools of mediation that have been provided in the training course.
Yeah. So in India also we have, for court annex mediation, there is a 40 hours mediation, training program organized by MCPC, that is Mediation Conciliation Project Committee of India. And from the time to time, these kind of, refresher courses and all these kind of, courses are done. One, it helps us to, remind about the main principles of mediation. And then mediators, they meet, they explore new ideas. We talk about so many new things, our experiences, what kind of problems we are facing when we are conducting mediations, like power imbalances when it is happening, what a mediator should do. Should he think about the neutrality part, or or the self-determination part wins. So these kind of situations are there. So these refresher courses, we are actually also adding new things, emotional intelligence of mediator. A lot of new topics are also added in those. And apart from them, there are very good private institutions who are conducted private mediations also. So in India also we are doing like the same thing, so that the mediator who is a mediator, certified mediator, has the right, knows the right way to conduct mediation and know
As
the
a matter of
rules
fact,
of mediations properly.
one of my colleagues, I had him come to do some training with the National Olympic Committee.
Okay.
Because, the multitude of sports bodies, we all have opinions, ideas, all sorts of things. So you will have arguments and disputes. And so it was very successful. I was surprised. We had people coming in from Central America that came to those sessions, because as nations develop and you into the international bodies, sporting bodies and so on, you want to make sure that you have your administrators have certain skills available to them. So this has been, the course was done by them, introducing them to sports law and sports mediation. Yep.
So I can see a question from Erica Gifford More. Yeah, ma'am, you can ask the question if you want to ask yourself. Please go ahead.
Yes. Somebody's asking.
Yeah.
Did he hear?
Oh, she was there. I saw.
There's a question. When can we have mediation training? I didn't get the rest of it.
Okay, no, so I will read another question meanwhile. I think she has to be.
She has to unmute.
Unmuted, yeah. So till that is done, I can ask another very important question, which I really like, is asked by Mr. Sabyasachi. Hello, what are the key questions that I need to think about when we are developing a mediation strategy for any case? So I think the mindset of a lawyer here coming into question, that what should be the key issues when you are there as sitting as an advocate in the mediation.
As the advocate sitting there, you pay attention, because it's human nature. There are things about us as Homo sapiens. So we think very carefully, because you know your client, or you ought to know your client and understand your issues. And you have to be strategic, because the other side, they're not what we call, we say, not going to Sunday school. There are issues. Sometimes the emotions can cloud issues on both sides. But as a trained lawyer, you look for your facts and your issues and try to sift. And in discussing with your client, You try to explain to them the expectation to listen, no cross-talking. You can listen, you can speak with me as the attorney. If you feel you may be doing your crosstalk while the mediator is present in the room, you can ask for timeout. Just make sure that you as the attorney, you focus on what is the issue and the cause at hand. What is the proceeding? Why did this thing ever come to court? And 50, well, I won't say 50, maybe 30 to 40% of the time, there is this little guy that sits on the shoulder that said, I'm not going to stop. I'm not going to think. I have to be victorious. I have to. And you have to think what the law is, what is you're trying to cure, what remedy you're seeking. And in sitting down at the mediation, you keep that in mind. It's not that the person may ask $100,000, but you know to yourself that $100,000 is not. He's just doing to scare the other side, terrorize the guy for him to go home, sleep, and say, you got to tell his lawyer, you want $100,000. I don't have it.
True.
So you have to sift that using your own training as an attorney when you're sitting there. Because initially, even though you explain to your client what mediation is about, initially, when they go into the room, you can cut the hostility. Is there you could. And the good mediator senses it, smells it, and levels. I have seen that in even a commercial mediation. The good mediator, his tone of voice, his posture, the way that he looks, his body language, eye contact with the parties and with the lawyers, and you can see the atmosphere simmering right down. You can see it. And the parties get comfortable because of the posture of the mediator a lot of the times. The mediator is such a good referee, such a good neutral person, that even the attorney, you're human, you will have, oh my God, where is this guy going? You know, he's not supposed to bring this case. But the mediator, I've seen it on more than one occasion, he lessens that sort of the temper of the attorneys. And you sit with your arms folded and you say, my God, look at how he has succeeded in bringing me quiet. Because, you know, we talk a lot as attorneys.
So we have to take off the hat of a lawyer and think in a different manner. Our body language changes, and definitely I think the communication skill of a mediator is a very important tool in his or her hand for a successful mediation. Definitely, I agree, totally, I agree with you, Rene. I think again there is a question by Ms. Jan. Suvarna Jan, if you're unmuted, you can ask your question, or otherwise you can write in the chat box.
Did she hear you?
I know they can hear me, I think, but they're not able to unmute themselves due to some
Rima, everybody has to put their questions on the chat box.
chat box only.
Yeah.
So please write the question in the chat box. I'm trying my best within the time limit to answer as much as we can. So there's another important question. Good evening, ma'am. Since mediation is an out-of-court settlement, is res judicata applicable on a subsequent suit on the same matter?
Well, let me put it to you this way. When it's not a quote unquote out of court, it is part of the court proceedings. It doesn't, you can do mediation before matter gets to court, but there is no written order between you. It's just an agreement between parties. You can choose to go to court and you put it in they wouldn't put it in the pleading, but the court will see that this is something that ought to go to mediation. It goes to mediation. When it goes to mediation and you have agreement, remember when it goes to mediation, there is a referral order from the court. It's in the court, it's court proceedings, it has a number and the parties, it has a court seal. The referral order is saying these parties have agreed to go, this is the mediator, an alternate mediator, this is the number of days to submit your memo, your bundle. Each party has to prepare a bundle, the bundle for filing, how many days, the length of the mediation, when they should come back with a mediation report.
Yeah.
So it is that report, in the first 3-hour session, you may not finish, but the mediator will do a report. And that report is read by the judge, and the judge will see what is the possibility. You had 4 issues, 2 are settled, 2 not settled. You started to talk. Okay, I give you all, do you think you benefit from a further session? And the parties can say yes or no, because it's still a voluntary process. You still have to consent to the mediation. If the parties feel they cannot benefit, there would be nothing else. The rules indicate that then the judge will make an order in relation to the issues that have been settled, reduce that to that, and then continue for the case management, where people may have to do witness statements and further disclosures, discovery, and it goes through the whole process of case management, and then the case management, the case review, to ensure everybody is ready, bundles exchanged, the court is ready, a date is given for trial.
Yeah. So no, if it is a court annexed mediation, it is like a decree of a court. The settlement is later on when it goes back to the court, it is like a decree of a court. So then definitely res judicata applies. You can't come back on the same issue. There are only few grounds, like if it is a fraud or like that, only then you can, it is appealable. Otherwise, it is treated like a court decree. So definitely you can't come for those issues again and again. It puts an end. That is one of the important benefit of mediation, I would say here.
Yeah.
That
Well, it's
it brings an end. Yeah, it brings an end. Am I right, Rene? Okay. So, any other questions, or I think we are ready.
Can I please ask, because I have been unmuted?
Okay, you can. Please.
Yes, please.
Okay,
Namaste.
this is our
Namaste,
last
ma'am.
question for the day.
Yes,
carry on.
please. Namaste, Ma'am Bandari. I just would like to mention I have lived in India for the last 5 years, and I came back to England. And I have a question for Honorable Mrs. Baptiste about indigenous group and how the groups which are perhaps scheduled or they belong amongst the Ministry of Tribes, which is a very relevant question in India because they do have a Ministry of Tribes. So my question, which I was dealing with as a young lawyer in India, so my question towards Mrs. Baptiste would be, what and how are the indigenous groups in Caribbean welcoming the mediators as an alternative form of legal representative for them? Are they more willing to collaborate with them other than with what you would call a classic, very sort of conservative, traditional way of representatives like attorneys? So is the role of a mediator easing the communication with indigenous tribes in Caribbean? Thank you.
Well, the history of the Caribbean will show you that we do not have, quote unquote, what you would be familiar with and call indigenous tribes. Okay, we barely have in St. Vincent persons whom you can trace their ancestry because they were displaced. But we still have some. But there's no tribal law so that you say this person belongs to this tribe and this is how they will settle disputes. So we don't have, they're totally amalgamated within the society. But I can tell you that some families, because some families, they would have the grandfather and the grandmother as the people who settle disputes. They get to the grandfather or the grandmother and they settle disputes. And in most of those disputes are to deal with who takes care of children, that sort of thing. But that does not come to the core as a dispute for court resolution. Huh? Now, I do not know, for example, in Belize, where you do have various tribes, and in Suriname, I have no idea of what is involved in those kind of disputes there, because I can only speak of the Eastern Caribbean, and in the Eastern Caribbean, Dominica has still the Kalinago people, and they have a little system but that does not mean that they are outside of the legal framework of the court.
So I think with this, we would like to end our session.
Thank you very
today.
much.
Thank you, Rene. And I'm actually having, there are less words. I don't know how to explain, but it was actually a wonderful, wonderful session. And I really extend my heartfelt gratitude to you and to all the participants who have made today's session a resounding success. And thanks, and we have learned how mediation evolved in Caribbean and how institutional mediation is coming up there and community mediation is coming up. And definitely we have learned one more thing, how to enhance community mediation by going to various groups. So definitely we all have picked up a lot from you. And so again, thank you so much, Rene. After this, I would like to say that I would like to take a moment actually for our tomorrow's program, which will be hosted by my colleague, Mr. Anil Shrivastava, tomorrow. And I also wish to take a moment and I would say and extend my sincere thanks to tomorrow's speaker, Mr. A.J. Jawad, who apart from being a very good mediator, trainer, amazing person, a good friend of mine, I can say and I can vouch for you this, that tomorrow's session again, like Rene's session, will be very enriching. As... Hello?
Nashi, come here.
Okay, I'm so sorry. I'm sorry. So his vast experience and deep knowledge in the field of mediation, as he's going to talk about the historical perspectives of legal systems and culture tomorrow. So I'm sure we will get some valuable insights from him
I'm in this, right?
to
If I want
understand
to
the
speak on
mediation.
the
I
chat,
think someone has
message.
we have to, I think, mute. I'm actually also deeply appreciative and want to say my thanks to Rahul and his team who provided flawless technical assistance, ensuring that our virtual session it runs smoothly. So thanks,
Maybe
Rahul,
2
again.
years, at least.
Your efforts behind this are
Background
definitely
meeting.
very valuable. And
Sitting.
with this, a special thanks to all the participants for your active engagement by asking so many questions. Your contributions have greatly enhanced the learning experience for everyone today. Lastly,
Maybe
I'd like to say that looking forward to see you again tomorrow at 5 p.m. Indian Standard Time. Till then, a good evening. Enjoy your evening today. Thank you.
Thank you so much.
Yeah.
Thank you, Rene.
Really
Thanks,
appreciate
Rima.
Rene.
Thanks,
everybody.
Rene. Thanks a lot.
Thank you.
Thank you, Rene. Thank you, Rima, for a wonderful session.
Thank you, Rima.
Thank you, sir.
Great.
Thank you.
Absolutely a
Dhanyawad.
wonderful session.
Dhanyawad, Mrs.
Thank you so
Bandari.
much for this
Thank you.
wonderful session.
Dhanyawad. I love your English, Hindi. Thank you.
Dhanyawad ji.
You've been in
Thank you.
India for 5 years, so your Hindi is
ठीक
very
है.
good.
Thank you.
Thank you. Thanks a lot. Bye-bye.
Bye.
Thank you. Thank you.
Bye. Bye.
Thank you, Rene.
You're welcome.
And then